Welcome back as we dig a little deeper into some of the things to remember when naming your beneficiaries. First, let's talk about the kids. You've decided to leave part of your estate to your children, but they are under the age of 18. What are some things you need to consider? Since they are minors, they first will need someone to manage them, a guardian. This guardian will have the same authority as you would have in taking care of them. If their other parent is alive and able, well, that's an easy and obvious choice. But a guardian is also needed over their inheritance. Your last will can create a trust to protect the assets that the kids inherit, either through your will or through a beneficiary account like a life insurance policy. The trust names a trustee who will be in charge of the assets. You will be able to indicate the age at which the children should reach before they are given control over the assets. The trustee must do what is best for the kids, and the funds can be used for their care, their education, or other needs. You can put restrictions on the distribution if there are specific things you'd prefer happen before being allowed to receive, like finishing college. Don't forget to consider an alternate guardian and trustee. You probably wouldn't want the court making that choice for your kids. Next, let's go over some things about naming multiple people to share in your estate. Here's an example. If you name your 4 children to share the bulk of your assets, what if one of them dies before you? Would the remaining 3 just take it all? Or would you prefer that the heirs of that deceased child receive that share? The law uses 2 phrases to distinguish between these scenarios. If you want the split to remain 4 ways, then you would say the inheritances are given per stirpes. The deceased child's share is preserved. On the other hand, if you are okay with just the remaining kids inheriting, then your will would use the term pro rata. There are other ways beneficiaries receive property when you die, and none of these become part of your estate and do not need to be named in your will. But we mention them here because it's a common question. Bank accounts and real estate can be held jointly with you when you're alive, so that when you die, the other account holder or property owner automatically becomes the sole owner. Real estate can also be transferred while you're alive through a transfer on death deed, which states the property is yours until you die and then becomes the property of whomever you listed on the deed. Life insurance policies and investment accounts such as an IRA allow you to name beneficiaries directly. When you die, the beneficiaries receive the proceeds and funds from those companies. There is no need for the court to get involved in distributing the proceeds, since they are not assets of yours the way your car, your house, or the cash in the bank would be. One final thought. After any major life change, such as a marriage, divorce, maturity of the children, births, and deaths, take some time to review your beneficiary designations. Make sure they accurately reflect your wishes. Thanks for joining me, and come back next time when we will shift our focus to a couple of less pleasant but still important estate planning items, your liabilities and your funeral. I promise the peace of mind is worth the time.